Ms. Mannon. Mr. Bogdanor? You may proceed.
My name is Michael Bogdanor, Your Honors, and I represent Charlene Waters, the mother of and the administratrix of Sean Waters, a state policeman killed in a drunk driving incident. I'm also arguing today on behalf of all of the other appellants in these cases. These are two different consolidated cases, a tort case arising out of a transportation by a limousine service on the night of the drunk driving incident, and an insurance coverage case arising out of coverage for the tort that we allege. I'd like to address the tort case first, if I may. The question presented, Your Honors, is whether a limousine service hired to transport passengers and permit them to drink unlimited amounts of alcohol, and in fact catering to that.
Well, excuse me, did the Livery supply the alcohol?
There was a small amount of testimony that there may have been alcohol in the limousine at the beginning of the evening. That testimony was disputed, and our primary argument is that the limousine service has a duty arising out of the transportation of the passengers while they drank alcohol,
In
as
the
opposed
car,
to
in the limo?
in the limousine.
And the evidence of that is clear? The evidence of that is clear?
The evidence is overwhelming. There were 6 passengers, and they had 60 bottles of beer and a pint of hard alcohol in the limousine.
And were drinking it in the limousine?
And drank it in the limousine. At the end of the night, all that was left was approximately 6 bottles of beer when the driver cleaned up the limousine.
Mr. Bogdanor, I know that when the limousine got back to the bar at the end of the evening, did the driver, and I know you talk about how the fact that the car that Mr. Powers was going to use was right there, but there's no evidence that the driver knew that that was Powers' car or that he had come by car, is there?
There's no evidence as to what the driver knew about how Mr. Powers was going to proceed after he was dropped off. The car was visible from the limousine, and the evidence...
Did he know it was his car?
I mean, did he have any idea that it was connected to the people that had been in the limousine?
There's not evidence as to what the driver knew about Mr. Powers' car. The evidence is, in fact, that the driver took no steps to determine how people were getting anywhere after he dropped them.
In your opinion, what should the driver have done? Restrain Mr. Powers physically?
In our opinion...
Say you can't, I'm not going to let you go, call a cab, call the cops and say there's a guy just let out of my limousine and he's stiffer than a mackerel? What could he do?
In our opinion, the duty of reasonable care spans a spectrum, and there are things he could have done that would have satisfied that duty.
Such as?
Such as making sure that each individual was given a very explicit direction that he would get them to their next place, preferably get them home, but at a minimum that he would speak to each individual in that limousine and make sure that they at least were provided an opportunity to get where they were trying to go after they'd been drinking not only the amount of alcohol that I've already described that was in the limousine, but also drinking at the bar that they were picked up
So
at.
if the driver says to him, look, pal, you're drunk. I want you to call your friend, your wife, your girlfriend, whatever. And the guy says, heck with you. That's okay?
Under those facts, had the driver spoken to each individual and said, look, you're drunk, I'd like you to either get a ride, preferably the driver would say, I will get you to where you're trying to go, I will get you home.
Forget the preferably part of it.
But even if the driver said to the passenger, look, you're drunk, and you need to be brought to the next place you're going, so call a taxi, or I'll call you a taxi, or call your girlfriend,
Mr.
etc.
Bogdanor, let me just, forgive me for interrupting you, but he calls a taxi and he puts the person into the taxi. Isn't he, and then the taxi driver drops him off. He says, fine, I'll get into a taxi. He says to the taxi driver, take me around the block, and drops him back at the car. Is the taxi driver liable?
That's why it's a spectrum to determine what falls within the
But
duty
what
of
would
reasonable,
happen, following
duty
up
of
on the
reasonable
Chief
care.
Justice's question, if we adopt your argument, then wouldn't taxi drivers become liable every time they drop off pick up somebody outside a bar, see that he or she is very drunk, and then they ask to be dropped off at their own car, which is a few miles away. What is the taxi driver supposed to do then?
In that setting where you have a taxi driver pick someone up who is drunk and drive them somewhere, it is possible that if that taxi driver drove them directly to their car and knowingly and did not actually offer them some other choice, such as, can I get you where you're trying to get, there may be negligence there. But
Airplane? What about an airplane that lets off some drunk passenger? Same thing?
No, but you don't have to go that far. I mean, isn't your argument really pinned to the, at least in part, to the open container law, number one, and number two, this is not a common carrier?
Our argument is separates this from the common carrier. That's true,
Which a taxi
because
driver
common
would be.
carrier has fixed stops, whereas this was a private transportation that was intended to permit people to drive to the point of to drink to the point of intoxication, and then had a duty to exercise reasonable care. As to all the different alternatives that all of you are proposing, there is a spectrum. And for example, my brothers, my adversaries here, have accepted that there's a duty. They have said that they would not drive someone while they drank this amount of alcohol and then drop them off in a parking lot in the middle of the woods. They would not do that. They knew that that would be unreasonable. The driver of this limousine said if someone was intoxicated, he said he would drive them home. He specifically testified if someone were intoxicated, he would drive them home. Why didn't he? He said he did not think this person was intoxicated. Someone who had had at least 21 drinks of alcohol in a 6-hour period, who was three times the legal limit. Yes, Your Honor.
Excuse me for interrupting you. Did the driver know that this person had had 21 drinks?
The driver knew that everybody in the van had been drinking.
Right.
The driver, I don't think the driver knew how many drinks. The lab director at Brigham and Women's Hospital testified that the blood alcohol level was represented something equivalent to 21 drinks, 3 times the legal limit.
So
The driver did not know exactly how many
Let's
drinks.
assume
Your
that
Honor.
we agree with you that there is a duty to exercise reasonable care. If the driver testifies, I didn't think he was drunk. I'm not there testing his blood alcohol. He was coherent. I don't know what the evidence is that the driver testified to specifically. Sometimes in a group like this, there's a designated driver. I mean, the fact that vast amounts of alcohol were consumed may not mean that every person consumed vast amounts of alcohol, correct?
That's correct, although the testimony was that everyone was drinking that night. Everyone was drinking in the bar at the beginning of the night, everyone drinking in the limousine, and again at the strip club they went to in Rhode Island.
But that's not, but the issue is whether the driver was in a position to know precisely whether this person had drunk so much that they were incapable of driving.
I entirely agree, and that's why it really is a jury issue, not a legal issue. It's a jury issue, because 21 drinks in this person, 3 times the legal limit, a jury could, and the driver knew that everyone's drinking, a jury could reasonably conclude that the driver did or should have known that this person needed at least some guidance.
May I ask you this?
What did the driver did say something to the passengers as he actually took some of the passengers requested to be brought home, right, or somewhere else?
That's not exactly correct, Your Honor. The driver's testimony, and again, this is a summary judgment setting. So, but even looking at
deposition testimony.
But looking at the driver's testimony, and then there was conflicting testimony also, but even looking at the driver's testimony, here's what he said. He said, after we got back to the point where I picked them up at the Sports Connection, a group of them were milling about in front of the limousine. I asked the group, he didn't ask, he specifically said, I didn't speak to each individual, but I called out to the group, did anyone need a ride? And he said only 2 people responded. They decided to go with him to a party that he was going to. So that's his testimony, and he testified he didn't speak to each one individually. So that's looking at it in a light most favorable to the defendant, which is not the correct standard. The driver asked the group, does anybody need a ride? And only 2 people responded. But what was the other testimony? The other testimony was that those 2 people didn't even get out of the limousine. They were going with them to the party. So it's unclear whether this I spoke to the group and only 2 people responded discussion ever happened. And the testimony was that the driver took no action to determine whether passengers were capable of getting home. That's in the record at page 828. So again, it's a jury issue. At best for the defendants, he saw a group of them afterwards. He said, anybody need a ride? And
The
only
duty
2
issue is
people
not a jury.
responded.
The duty issue is not a jury issue.
Correct, Your Honor. And
That's a legal issue.
and I don't actually think that the defendant disputes that there is a duty, because the defendant has already testified. The testimony here is they knew they shouldn't drop an intoxicated passenger off in a parking lot, say in the woods.
Let me ask you a follow-up on that. Now, we're talking about a situation where the driver has been hired to transport. Would you say that the duty also applies to the situation where a person has been the designated driver for a group of people and they go out and somebody gets really intoxicated? Does the designated driver of that group, even though they haven't been hired, do they have a duty to make sure that person doesn't drive after they drop them off?
Again, there's a couple differences there. One is that is not a paid professional person,
yeah.
so that's one distinction. Second of all, of course, in that setting, the people could not be drinking in the vehicle, whereas here, under the law, commercial transportation service is permitted to allow people to drink in the vehicle. So there are differences. However, and it's one reason that I sent a letter to this court last week, there is a recent Hawaii case just from 2 years ago that recognized there's not a lot of designated driver liability law out there, but the Hawaii case looked at the various cases on point and concluded that yes, even a private designated driver owes a duty of reasonable care as to what happens to those
Is that
people
your
in his
position?
care. I believe that a designated driver should have a duty of care to exercise reasonable care as to what that driver does with the persons in his care. But again, on these facts, we have a much more compelling case.
Defendants, at least the limo service, accepts that a duty exists. What are we doing here? The insurance coverage is a different issue, but if they accept that, according to you, why was summary judgment granted?
Legally, they take the position that there's no duty of care.
Yeah.
Legally, their argument. And Judge Brady concluded there's no duty of care. But when you look carefully as to what the owner of this company and the driver has testified to, you can see they know that there is a duty of care. They know.
Might be a duty of care, and I take it you would recognize that limitation on a private, designated driver situation. There might be a duty of care to the passenger. Right? In other words, I haven't looked again at the full deposition testimony, but I take it if somebody says, I knew he was absolutely blind, I knew he was blind drunk, and I dropped him off in some lonely place, where he couldn't have got assistance, and then it turns out that he, dies because he trips and falls or something. Isn't there a difference between a duty of care to the passenger that might, as opposed to third parties?
I don't believe there's a difference at all, Your Honor, because the people that are foreseeable to be harmed if a highly intoxicated passenger is dropped off where it's foreseeable they will drive are the public at large, the motoring public. And especially, again, in the commercial setting, where the purpose of permitting the commercial transportation service to allow people to drink is to prevent and reduce the risk of drunk driving. That's another place where we agree with the defendants and with the amicus brief, which is that the purpose of all of this, the purpose of the law, should be and is to reduce incidents of drunk driving. And the citations in the amicus brief of all the websites that say that, all of them say the idea is to prevent the passenger from getting behind the wheel of a car.
Well, if they dropped him off at his house, what prevents him from getting into his car and driving someplace else?
At least then they would have exercised reasonable care. Then, on those facts, it is likely that if summary judgment entered, we would not have a strong appeal, because there, at least you did the best you could, but he didn't do the best he could.
I thought he was dropped off 4 blocks from his mother-in-law's house, or from, isn't this bar like very close to his in-laws?
Yeah,
Wasn't his wife going to
nobody
pick him
knew
up?
that.
As far as that, there's no evidence whatsoever. He, I believe, lived about a mile from where he was dropped off at the Sports Connection. There was no evidence. He had a family member who might have lived nearby. There's no evidence the driver knew any of that or asked anything. The evidence is the driver did not ask, how are you people getting to where you're going? The driver didn't think that was his responsibility.
Mr. Bob,
yes.
I'm sure you can tell from the import of the questions that the justices are concerned with what the outer limits are right? And at the beginning you said, he had a duty of reasonable care. I wonder if you could try to narrow that to whom and what circumstance. It's just a duty to the entire world. So your position would be if the driver, private or retained, private designated driver or hired, has some reason to believe that a passenger in his car is inebriated, the driver has a duty to the world?
I would if the wording of that duty would be if a commercially paid driver
So you leave away designated drivers,
who
private.
is, I don't think we need to reach that issue. So a commercially paid driver who is only permitted to allow people to drink in his vehicle under legislation that excludes him from other private persons has reason to believe that his passengers are intoxicated. He at least has to exercise reasonable care to give them the opportunity to get somewhere safe. And that exercising of that reasonable care could be done in numerous different ways. Can I give you a ride home? How are you getting home? Speaking to each
And
individual.
you would
That's a
say
fact spectrum.
If he offers, but the offer is not taken up, that is sufficient to satisfy the duty?
I believe if he offers to each individual, if he does what he can to each individual to make sure that they know that he will get them to a place of safety and they reject his advice, he's done all that he can do. He did not do that in this case. At least the evidence on that is conflicting. And I would direct the court to a case that my brothers rely on, if I may just take one second. The Supreme Court of Maine recently addressed this in Mastriano, and it was a divided court in that case,
Right.
and it's cited by my brothers, Mastriano 779, A. 2nd, 956, and the two justices dissenting pointed out something as simple as if the designated driver brought the person home to a hospital, a bus, an airline terminal, they would have exercised reasonable care. Just dropping them in the middle of an intersection where they are parked and where there's a closed T station and not even finding out how they are going from there, that's just not enough.
Thank you, Mr. Bogdanov. Mr. Rosenberg?
Good morning. My name is Kenneth Rosenberg, and I represent Ultimate Livery Service and Richard Broderick. It's our position that the law is clear that there is no duty owed by the livery service in this case. There was no affirmative act of providing the alcohol to any of the passengers in the vehicle. We believe the record is clear on that. There's
But, fine, I mean, it isn't quite, but I'll accept that. But what about this idea that this is a commercial enterprise in this business? There's a specific exception in the open container law to allow such an enterprise to drive people and allow them to drink in the car. Doesn't that distinguish this from a lot of our other, any social host or even the designated driver? I mean, not that we have law on it, but
There would only be a duty while the passenger is still in the vehicle. Once a passenger has been discharged, the passenger becomes a traveler on the way. That's what the Betancourt decision says. That's what the restatement, Section 314, Common C says. Once a carrier has discharged the passenger becomes a traveler on the way to which no further duty is owed.
Couldn't we look at this a little bit differently? I don't know what the restatement says, and certainly the restatement could be very helpful on this whole issue, and we'll look at it. But here you have a commercial contract, do you not?
Yes, we do, Your
Which
Honor.
the average person enters into because they are looking, in many cases, for safe transportation from point A and point B because they're going to a party or a wedding or some other such thing. So inherent in the contract is not only that, but the fact that a lot of alcohol is going to be consumed and you want to get home safe, right?
Yeah,
Not
but
get arrested for drunk driving and certainly not cause the sort of accident that occurred here. So aren't these contracts unique?
I don't think they're unique. You have a contract, and if you look at the contracting parties here, the livery service had the agreement they were going to pick them up at the Sports Connection and drop them back off there. If you look at Brian Massey's testimony in the record, he understood, and he's the individual
Well,
who entered into the
that may be
contract.
what they signed, but wouldn't the law impose another term on the contract if we wanted to impose that term?
I think you have to look at what the contracting parties intended, and they intended to hire a limousine to pick him up at point A, drop him back off at point A at the end of the evening, and that was the nature of the contract between the livery service and the individual who rented the van. Otherwise, where would any duty end? Where would the livery service drop off these people, and what would happen 4 or 5 hours later? Would the delivery service have to wait until the person sobered up when that duty ended?
Well, do we have to worry about that in this case? If we find the duty exists and we find that he did nothing really to discharge it, or if a jury could find that, not us, we'll worry about all these other hypotheticals later.
Well, he discharged them on the sidewalk. There's testimony that they were milling about on the sidewalk for several minutes smoking cigarettes. It's not as if they discharged these individuals in the middle of the Massachusetts Turnpike or in some ditch. In that situation, there would be a duty
Yeah,
perhaps that was
but he
breached.
saw him get into the limousine with, I forget, what was it, 60 bottles of beer or something, or
No, that's not the testimony. They
whatever
got
the
into
deposition
limousine,
is?
and then they were driven to a liquor store where they purchased, I believe, a 30-pack of beer, and they consumed some of that in the limousine.
2 30-packs.
2 30-packs.
Yeah.
They consumed some of that to the limousine, then went down to Rhode Island, then came back in the limousine to the place where they were picked
Was
up.
there evidence that the limo driver saw this person get into his car?
No, there's no evidence of that. In fact, the evidence in the record is all of these individuals basically lived around the bar within a 4 or 5 block radius, and the evidence is that although the driver did not know it, most of the individuals walked to the bar in the beginning of the
But
evening.
that doesn't
That's-
really help.
Yeah,
with
that's all for
respect
the
to
jury.
Yeah.
Was there a fact question whether the driver, though, had stocked the car with alcohol before the passengers got
No.
into it?
There's one individual, Mr. Podolsky, who in his answers interrogatory said, when I got into the vehicle, he believed there was alcohol in it. When we took Mr. Podolsky's deposition, he said, I had no idea about anything. The interrogatory answers I gave 4 months earlier, I don't even remember saying
But isn't
that.
there still some evidence that the car was stocked with alcohol?
There
Just
isn't,
because he
because
now repudiates it doesn't mean that it doesn't exist.
But how could that individual take the stand? What would his direct testimony has to be consistent with his deposition that either I don't remember or I had no idea that I answered these interrogatories 4 months earlier.
Or
And
maybe
that-
he'll have some memory improvement between now and trial.
Sorry, go ahead, Justice
I just
Wilson.
wanted to ask you, the restatement, though, is all about common carriers, which your client was not, correct?
That's correct, except restatement, I point to the restatement because the plaintiffs, at least in their original brief, talk about the restatement as creating a special relationship. And my understanding of the law is you only owe a duty to the general public if there's a special relationship that exists, because there's no duty to prevent harm to third persons unless such a relationship exists. And there's no special relationship here that's created by any statute or created by any portion of the restatement that the appellant points to.
The contract, the
Mr.
unique nature of the contract doesn't create that special relationship?
I don't think so. I think, as I understand Irvin versus Ware and that line of cases, it's usually based on some statutory violation.
But what about the Milford case? In other words, a store, a liquor store, right? Somebody comes in, buys liquor, is intoxicated. There's a duty to the people that get hurt or killed when that person goes out and drives again. That's
But-
not a special relationship.
No, it's created because of a statutory violation of either selling the alcohol to a minor or selling the alcohol to someone that's already intoxicated. I think those are statutes that control the tavern or the bar room. Just
Mr.
like the social host cases, you need the actual affirmative act of providing the alcohol to create the duty.
Mr. Rosenberg, do you see any distinction in the following hypotheticals? One, parents arrange or the school arranges, somebody arranges for a limousine company like your client to come to a dance. The limousine driver picks up people under the age of 21. He does not see them consume alcohol. They're boisterous, but he doesn't see them consume alcohol. He doesn't actually have alcohol in his car. And so he has, they may have been rowdy, maybe he might have smelt their breath, but he testifies they got in the back, I was with a shade, I didn't know, and I really wasn't listening. But they are absolutely plastered. but he doesn't actually know that they stopped off. He didn't see, dozens of cases of bottles of beer being brought into the car. Isn't one of the things that is that different from this situation where the driver knew they were stopping off? He didn't violate the law. You can drink in the car,
I think the
but he
issue
knew. He actually saw it. In other words, there was something that would have triggered his knowledge that they really were inebriated.
I don't see any difference, except perhaps in that case you're dealing with minors, but I think the ultimate issue is, does this driver have any right to control the activities of these passengers once they've departed the van? And I think when you look at the social host cases, it talks about a right of control of the alcohol that you're giving to these people. Just like in this case, the limousine driver had no control of the alcohol, they have no control over these passengers once they leave, because where do you draw the line? Where does a duty begin? Where does a duty end? It's just impractical to impose any type of duty, because it would go on forever. They'd have to wait until these people sobered up. Taxi cab driver could not pick up an inebriated passenger, because where would the taxi driver drop the person off? I mean, there's no fine line where there could be any practical way of where duty would begin and where duty would end.
Thank you, Mr. Rosenberg.
Thank you, Your Honors.
Mr. Hurley, good morning.
Good morning. My name is John F. Hurley, and I represent Commerce Insurance Company. Commerce had filed a declaratory judgment in this case, which was consolidated with the underlying case. Commerce had, in effect, for Ultimate Livery, two different insurance policies. One was a liability policy, but it contained an endorsement called the Designated Premises Endorsement, and it limited coverage to injuries arising out of the premises shown on a schedule, which case, or on the declarations page.
Well, in their brief, plaintiffs say, not you as plaintiff, but the injured plaintiffs, say that Commerce concedes that its business coverage policy is a general liability policy. Is that a correct statement?
Not exactly, Your Honor. There is a general liability policy to which it is attached this endorsement, and the endorsement is the Designated Premises Endorsement. The cases, some of the cases that I've cited and that have been cited, it's the same situation. There's a liability policy and an endorsement. I think sometimes you can have a separate policy, which is just a premises policy. But I think the effect is the same.
Mr. Hurley, just to follow up Justice Cordy, in the reply brief of Mr. Bogdanow, he says that your client has admitted that the business owner's policy was not a premises liability policy, but rather a general liability policy that, quote, provides liability coverage for non-automobile related accidents. So you would take issue with that, I take it?
Yes, Your Honor. I mean, there is a liability policy, but then there's an endorsement attached to it afterwards, which limits the coverage to the premises or operations necessary or incidental to those premises.
Well, I take it, though, that regardless of the policy, the theory here, the theory of coverage, is under the premises liability, is under a premises liability theory, and there is an exclusion as to premises liability, which limits coverage to injuries which occur on the plant.
Which says arising out of premises or operations necessary or incidental to those premises.
What about the lack of instruction about what the driver is to do with a drunk passenger? Wouldn't that arise at the premises?
Well, there's no evidence of that.
I thought there was something in one of the briefs that there was no instruction given.
There was no instruction given. There's no evidence that that's where the instruction would be given. The driver actually picked up the vehicle at a different location in Canton. The designated premises was in Boston or Columbus Ave.
On the interpretation of that provision, and particularly the necessary or incidental portion of it, the judge cites some cases that go in your direction.
Yes, Your Honor.
Are there cases that go in the other direction, too?
Yes. There are cases
all over the lot
from the other jurisdictions that are all over the lot.
covering that exact language or dealing with that exact?
Sometimes it's that language, sometimes it's different language.
Well-
Different, or slightly different. Sometimes it's, instead of those premises, the term is used, or incidental thereto, and the courts think that's
Oh,
different.
there are cases to construe that limitation, if that's the right word, to impose liability off the premises.
Well, sometimes it may be something that was actually purchased on the premises. It might be a retail outlet, and then they take it somewhere else.
It
and
seems just-
the
The
accident
garage,
happens.
there's a garage case that's cited, right, where the
Yeah.
car is, there's some accident in the car thereafter?
Yes, Your Honor, but that, I think, is completely distinguishable. It's a different type of policy. It's different language. It's not this designated premises language. It talks about...
Just seems to me to
covers-
be common sense that operations necessary incidental to the premises are the use of these limos to convey people back and forth.
Well,
Otherwise, what's the point of having the building and garaging all the limos and servicing them and maintaining them and all the other kind of stuff that goes on at these places?
well, if you have the limitation provides coverage in limited circumstances for non-accidents in which the limo is involved. So it would provide coverage for people who fell on the premises or other
The
things that
limo
might
went
happen on
out,
the
if the
premises.
limo went out and the driver, forget about all his drinking and everything else, rear-ended somebody and killed him, are they covered under these policies?
They're covered under the auto
Auto
policy.
Under the auto policy?
Covered under the auto policy.
Mr. Hurley, just following up with Justice Glaney, if one doesn't know anything about the case law, and you simply come at this cold and read the text, you've got the ownership, maintenance, or use of the premises, right? And then it's the operations necessary or incidental to those premises. So that suggests that there are some circumstances when it's off premises, correct?
Not necessarily. It could be things that happen on premises that not related to the condition of the premises, or
To the maintenance.
one might argue that it could apply to this retail-type premises. If someone sold I don't know, right, there's a case of someone selling, I think, a wallpaper steamer, and it's not, it's defective, and someone gets injured, they take it off the premises, that might be covered. There's some cases where that is covered. That's different, it seems to me, where there's been an auto accident miles away, not involving the
I
vehicle.
understand. With this coverage, assuming that, I take it that if a third party, the public, comes to the premises and is injured on the premises, this provision, the ownership, maintenance, or use of the premises, does or does not cover?
Cover it,
Covered.
provide coverage.
If the premises of a business are in essence not only the physical building, I think that was the import of Justice Glaney's question, this happens to be a business where the premises are its that's where it's conducting its business. Could one not say that this is an unusual situation? In other words, it's not the usual premises where somebody's engaged in the business of making ice cream, and then something happens everything happens on premises. Here, the very nature of the business is not in that building. The premise, as it were, is the limousine.
Well, I think if you interpret it that way, then you're really interpreting away the endorsement, which is what Judge Brady held, and which is what some of the cases he relied on held, and is also what's relied on by the Superior Court judge in the case I sent the letter on that was just decided.
If the limousine were not properly maintained, and, for instance, the brake fluid drained out, and the driver went to hit the brakes, and there were no brakes, and he crashed into something and caused damage, would that damage be covered under the premises policy or under the auto policy?
I would say the auto policy, because there's operation, use, and maintenance of the auto. And the premises policy also has an exclusion for accidents that arise out of the operation, maintenance, and use of the auto. On the auto policy, just briefly, that's an issue that the court has addressed many times as to where they're going to draw a line as to what's use of the auto. Judge Brady said that had there been evidence that the limo company supplied the alcohol, that there would be coverage under the auto, that would be use of the auto. We disagree. We say that there really isn't an injury arising out of the use of the auto. There's the Ruggiero ambulance case and other cases. And pretty much it seems like when there's a decision that arises out of the use of the auto, it involves something happening at or near the auto. Either someone throws a projectile out the window, or someone gets hit by the car, or something of that nature, and not something this far away.
If the driver had supplied liquor to the occupants, is there any coverage?
Well, Judge Brady
Brady
said there
would say
was, but
yes.
we would argue that there isn't.
Could I just ask one question? I know this is just a quick factual question. You say the business policy has an exclusion for automobiles, right?
Right.
Use of the
Yeah,
Use of auto- So as far as this necessary and incidental, insofar as the argument is it relates to the use of the automobile, doesn't that exclusion cover this for the business policy?
I'm not sure I understand.
Well, the business policy has this language about necessary or incidental to
Right.
I mean, the premises
Premises.
piece of that. If that same policy also has an auto exclusion,
Yes.
and in this case, the argument about necessary and incidental is the use of the limo, doesn't the exclusion for autos cover, even if there were normally coverage for things that are necessary and incidental, and it might include automobiles, in this case, because of that exclusion, doesn't the exclusion apply, or is that your argument?
Well, the issue is if the court finds that the auto policy applies, then the exclusion kicks out the business policy no matter what. If the auto policy doesn't apply,
okay.
then I'm saying that the exclusion isn't an issue, but the business policy doesn't apply either.
Got it.
Thank you.
Thank you, Mr. Hurley.